then Mr. McIntyre is present, correct?
Yes, Your
Yes,
Honor,
ma'am.
and, I have an associate who,
Right behind you.
oh,
All right, yes.
and announce.
All right, so how much time are you all asking for jury selection? An hour each?
Fine with the state, Your Honor.
I think probably an hour will do fine, Your Honor.
All right, does anybody want a time announcement?
Judge, yeah, 15 minutes.
15 for me as well.
All right, so then,
And
yes.
Mr. Hunter is going to be doing the board doc. You
Okay.
don't have to put up.
Well, I like putting up with you.
Thank
And
you.
I wouldn't even say putting up with you. I just always am happy to see you here.
It's our pleasure. Your Honor. Thank you.
All right, so let me know when everything is set up and I'll bring the jurors in. So just so you know, we can go off the record. Just so you know, the jurors will raise their cards.
I guess this is how many T-sips does it take to screw in a light bulb?
You know, it took
So, I
some
mean, we have
vitamin medicine
this one over here. If y'all need.
and the allergy. All right, are you all ready? Is your equipment up?
Almost. I think we're just confirming that something works.
Can I run to the bathroom real quick? Jeff?
Yes,
Is there one closer? or should I
yes.
go?
If you just go around the back door and you'll see it in the hallway.
Anything else?
All right. And defense? If
Sorry.
if
Tell me
there's
it's
an
working?
issue
Yeah,
with,
we're good. It looks like it's good.
all right. And if there's an issue with his eyeglasses,
Yes, Jerry, probably the eyeglasses. Jail.
so if you'll let me know about that. If neither party has any objections, I will contact them and let them know that he's to have eyeglasses. I don't know where they are though.
Well, he has a pair on him at the moment, but there's a stronger pair that we were hoping to have for this, so he can make sure he doesn't recognize someone. That we dropped off at the jail, but it didn't apparently make the ship over from the jail to here.
All right. Well, let me just tell you all, if you all have a second set of glasses for tomorrow, if you want to bring those with you, and then we can see about getting them transported. Okay. All right, let's bring the jurors in. All right, everyone, please be seated. All right, everyone, good afternoon. That is that's like a non-response. We're going to start over. Good afternoon, everyone. Thank you. I'm hoping you all are wide awake. I know that you all had an early morning because you were rushing, because I know they tell you to be here by 8, and then you were standing in the hallway. So what I can tell you is that in this courtroom, I still have a docket, even though we have jury trials in the afternoon. So the fact that you were standing in the hallway and then sent to lunch is not the fault of the state or the defense. It's just the way our docket is run. Does everyone understand?
Yeah.
Right. So you are in the 187th District Court, 4th floor with Judge Stephanie Boyd. What floor are you all on? What's the court number? Who's the judge? Oh, you all are the first jurors who did my first and last name. And I know you're probably saying, we know where we are. We've been standing out in the hallway. Why would you ask such a thing? The reason why, thank you so much. The reason why I ask that is because sometimes we may take a break. And when we take a break, all of you have to leave the courtroom and then you have to come back. And believe it or not, sometimes people get lost. We've had panels where we've been looking for a juror and they've been trying to get on another jury. And they say, either they say, I looked up, everyone was gone. So to my left, I have the court reporter. Cindy, could you raise your hand? I always said, if ever I were in a position to make somebody's job easier, I would do the best I could to do that. So she takes down everything that everyone is saying. So if you can imagine, that's very difficult because everybody speaks at a different pace. Some people whisper, which I'm going to ask you not to do today. Some people talk extremely fast. So when you're answering questions, if you'll speak at the pace that I'm speaking and at the tone that I'm speaking at, that will make her job so much easier because I'll be able to hear you. She'll be able to hear you. And I've already talked to the state and the defense. People who have glasses, where are my eyeglass people? All right, so everyone, eyeglass people will tell you this. Something has happened to us since we've started wearing glasses. We really can't hear unless we see as well. So I told the state and the defense not to block you when you're speaking so that I can hear you, so that Cindy can hear you. Now, this is the state of Texas versus Taymor McIntyre. Could I have the state, if you can introduce yourself, please?
Jason Garahan for the state.
Good afternoon, Megan Galloway for the state of Texas.
And for the defense?
There, John Hunter and Jerry Goldstein, Thomas Lane for Mr. McIntyre.
And, let's see,
And a law clerk, Fabian Longoria over there.
All right. And Mr. McIntyre, if you can introduce yourself, please?
My name is Taymor McIntyre.
All right, you may be seated. Now, in your possession, you have cards. And you also may have some clickers with you as well. Could everyone please raise your cards and do not lower your cards until I ask you to lower them? All right, when I ask you to lower your card, you may lower your card. Jurors 1 through 21, if you can lower your card. Everyone else, to make the court reporter's job easier, whenever you're speaking, I will need you to stand if you can stand, because the acoustics in this courtroom is not great, and the court reporter will be able to hear you, and I'll be able to see you and hear you as well. Can everyone do that? I'm going to tell you what I've told jurors before, and we do jury trials at probably about once a week. Every juror that I've ever asked that of, they said, yes, Judge, we will do it. So I have faith in you. Every jury up until this point have failed at that instruction, but I have faith that you guys will follow through. All right, you can lower your cards.
Judge, briefly,
Yes.
would you please ask them to confirm that the clicker that they have has a number on the back that matches the juror number?
All right, thank you. So everyone, you have your juror numbers. The white clicker that you have, can you make sure that that matches your jury number? If there's anyone who has a clicker and it doesn't match your juror number, would you please raise your card? All right, so I've had the parties stand up for you. Does anyone recognize any of the parties that have stood up and introduced themselves to you? Now, what I want to talk to you about is the charge in this case is capital murder. This is a criminal court. And I'm going to come back and talk to you about the charge in a little bit more. But this is what I want to let you know. The state nor the defense can tell you what they think the facts of this case are. Everybody will be speaking to you in hypotheticals. The only time you will be able to know what either party thinks the facts are is during the jury trial, and if you're actually on the jury. So don't go all bewitch Mrs. Kravitz on me and try to think, oh, those are the facts of this case, because neither the state nor the defense is allowed to tell you what they think the facts are in this case. Does everyone understand? So both parties are going to be talking to you in hypotheticals. They're probably going to talk to you about the charge or maybe some lesser included charges. Does everyone understand? Now, an indictment. What is an indictment? An indictment is a piece of paper, and it is the means by which someone is held over for trial in a criminal case. Does everyone understand? Raise your card. We're going to practice now. Raise your card if you've ever had a traffic ticket. All right, so this is what I can say. San Antonio has some of the worst drivers. And the reason why I say that is because the cards that are, more and more cards get raised all the time. You may lower your card. I can say that. I had a traffic ticket before. So hypothetically, let's say you got a traffic ticket, an officer pulls you over. Let's say they pull you over for running through a stop sign. All right, when the officer pulls you over for a stop sign, when I received my ticket, it wasn't for a stop sign, but it was a speed trap. But when they pull you over in a different state, when they pull you over and they give you a ticket, for me, they just write on a sheet of paper and they would give it to you, and they had carbon copies. Now I think it's done electronically. When they pull you over and give you that ticket, on that ticket, it's supposed to tell you, hey, I'm pulling you over because you ran a stop sign. And they will tell you, this is the court where you need to be to answer for running the stop sign. And in Bexar County, usually it's Frio Street, the municipal court. When you accept that ticket, you're not saying, you know what, officer, you're correct. I did run a stop sign. The only thing that ticket is telling you is what you're being charged with and where you need to be to answer for those charges. It's not evidence of anything. And it's the same thing with an indictment. An indictment is not evidence of anything. It cannot be considered as anything. The only purpose of an indictment is to tell somebody, this is what you're being accused of, and this is where you need to go to answer for what you're being accused of. Does everyone understand?
Yes.
An indictment cannot be used as evidence. It cannot be taken by you to mean anything. Does everyone understand?
Yes.
Is there anyone here who's going to hold it against Mr. McIntyre because he's here by indictment? Now, the next thing I want to talk to you is certain rights that people have. One is the right to remain silent. That means that if you're charged in a criminal offense, you don't have to testify if you don't want to testify. I've been a defense attorney. I've been a prosecutor. What I can tell you as a defense attorney, sometimes I would tell my client, you want to testify, you really don't need to. The state can improve their case. And then my client would make a decision on whether to testify or not. And sometimes I would have to tell my client, look, you're nervous talking to me. That's not going to look good in front of a jury that you're nervous. So it's probably best that you not testify. We can still do other things with your case without your testifying. And my clients would be like, okay, Stephanie, you're right. I am nervous. Then some people are afraid of public speaking. Some people have speech impediments and they're just like, no, I'm too nervous and I'm afraid to speak. Does everyone understand? But what that means is, because you have a right to remain silent, what it means is in criminal cases, if someone decides that they're not going to testify, you can't hold it against them. If you were deliberating on a jury, you can't say, you know what, that person didn't testify, so that's a strike against them. You're not allowed to do that. And I've had people that have told me before, oh, well, if that were me, I would want to tell my story and testify. This is what I would always tell people, but it's not you, and you're not in that position. Once you're in that position, maybe your opinion will change. You know, the more knowledge you have, sometimes is great. Does everyone understand? So in this case, Mr. McIntyre has a right not to testify, and you cannot hold that against him. You cannot consider it. You cannot be like Mrs. Kravitz thinking about, oh, I wonder what he would have said. Does everyone understand? Is there anyone here who cannot follow those instructions? Is there anyone here who's going to hold it against him if he decides not to testify? Is there anyone here who's going to consider anything about his not testifying if he decides not to? All right. The next thing I want to talk to you is presumption of innocence. Anybody who's accused of a crime is presumed to be innocent. Now, what does that really mean? That means that when they come to court, they're cloaked in the presumption of innocence. And the only way that cloak is removed is if the state proves its case beyond a reasonable doubt. And they prove each element beyond a reasonable doubt. Does everyone understand? So what does that mean? That means that then the state would have to produce evidence for you. So as we sit here right now, how much evidence has the state presented? So if you had to vote on whether Mr. McIntyre was guilty or not guilty right now, what should it be? All right, so proof beyond a reasonable doubt, because that's the state's burden. What does that mean? When I went to law school, there was a definition for proof beyond a reasonable doubt. You had to know it backwards and forward. If you didn't know it, you felt like such a failure. When I had my very first jury trial, I knew it. I knew where to add the exclamation points where needed. I knew where to pause for dramatic effect. See that pause? So I knew where to do that. Then after my first jury trial, guess what happened? There is no definition for proof beyond a reasonable doubt. It does not exist. So I said to myself, how am I going to explain to the jury what proof beyond a reasonable doubt is if there's no definition? So I started explaining it to them by telling them what it wasn't. Next door, the building that has the green rooftop, the historic courthouse, they try civil cases. And their burden is different from the burden on criminal cases. They have a burden over there that's called preponderance of the evidence. What is that? More likely than not, something happened. So if you're ever on a criminal jury trial, be it a misdemeanor case or wherever it may be, if you're deliberating and somebody says, yeah, I think this happened more likely than not, then you are not at the correct burden. You have lowered the burden. And the burden in criminal cases is proof beyond a reasonable doubt. It's not more likely than not that something happened. Does everyone understand? The other burden they have over there is what's called clear and convincing evidence. Clear and convincing evidence is a lower burden than proof beyond a reasonable doubt. Clear and convincing evidence is the amount of evidence that's needed to terminate your parental rights. They say you're a bad parent. We think you're a danger to your child, so you will no longer be allowed to parent this child. People say that's a high burden, but guess what? It's a lower burden than proof beyond a reasonable doubt. Proof beyond a reasonable doubt is the highest burden we have. Does everyone understand? Now, proof beyond a reasonable doubt doesn't mean a shadow of a doubt. Where are my Perry Masons, my Mannix people, my Barnaby Jones, my paper chase people? Okay, so people are shaking their head, but I don't see any cards raised. I see some people, you look young, but I see, thank you, number 26. So it's not a shadow of a doubt. That's not the state's burden. The state's burden is proof beyond a reasonable doubt. Do you have a doubt? Is it reasonable? That's their burden. Does everyone understand? Now, the next thing I want to talk to you is about media, publicity. In this courtroom, if you are selected as a juror, you're supposed to base your decision, if you can come to a decision based upon the evidence that's presented to you. Does everyone understand? Not based upon what somebody is saying on the outside, because how many times have you ever seen a jury trial and you watch it on television and you're saying to yourself, I can't believe a juror would make that decision. How could they make that decision? And it's because maybe that juror had different information than you have. Usually when you see things on television, when you see things on media, it doesn't really tell the whole story because they have to condense things. So with regards to media, let's say you have Oprah Winfrey on trial for something. Is there anybody here who doesn't know Oprah Winfrey? All right. So I'm just using this as high, or Sting, or Mick Jagger. Is there anyone here who doesn't know Mick Jagger? All right. So let's say Mick Jagger is charged with an offense, right? And you all have just told me that you know Mick Jagger, right? So let's say he's charged with an offense. And let's say Mick Jagger is charged with a theft case, right? And you get selected as a juror, you're called up on a panel like this, and people want to know if you can be fair. They want to know if the fact that he's Mick Jagger, is that going to mean you're not going to be fair? Are you going to be saying, you know what? My understanding is Mick Jagger is in the middle of writing another song and they have a concert tour. And maybe I want to be able to see his concert tour. So, you know, I'm going to do things differently because I want to see more Mick Jagger in concert. Well, when you have people who are media personalities and we feel like we know them, right? Sometimes you feel as though, well, I know that person personally because I see them every day. But when we talk about fairness in cases, you may have seen somebody on television, may have seen somebody on Facebook, X, or Twitter, or YouTube, MySpace for the older people. All right, you may have seen them on those different platforms, but the question becomes, even if you know of them from those platforms, fairness is whether or not if you are selected as a member of a jury, will you be able to listen to what evidence is presented to you, not about what you've seen on social media, but what is presented to you about that specific case? Will you be able to listen to the evidence and make a decision, if you can, on whether somebody's guilty or not guilty? Does everyone understand? I always tell people it would be great if for jurors, we could have people who were born yesterday and slept all last night, but that's not the way the world is. The way the world is all of us have had things that are happening in our lives. All of us have seen things. Does everyone understand? So when we speak about fairness, what fairness really means is, even though something bad may have happened to your life, even though maybe you've seen something, that you will be able to sit and listen to evidence and make a decision, if you can, based upon the evidence that you may hear. Does everyone understand? People will always give an example of, you're scheduled for jury duty and you desperately want to be on a jury. So what do? You plan, you're like telling your neighbors, I got called up for jury. This is so exciting. I'm gonna do my civic duty. You map out how to get downtown. You research how much parking is going to be. And when you wake up the next morning, you wake up extra early because you know it's school in session. And when you wake up, you come down and your vehicle is on cinder blocks, but you still want to do your duty. So what do? You get an Uber or take the Via, or have your neighbor, they bring you down and you're still excited. And they call you up and you're standing in the hallway and you finally get called in and you find out that you're going to be sitting on a burglary of a vehicle case. That's usually the example that people will give you, and people will say, so you're really not a great juror for this. This really is not the jury for you. And people will usually say, no, this really is not the trial for me. But that's really not the proper question. The proper question is, if you were involved in that hypothetical and you're that juror and you're called up for a case and somebody's charged with burglary of a vehicle, are you going to be in the jury box and you're going to say, you know what, my car got burglarized? Maybe it was that person, I really don't know, but I'm just looking to find anybody guilty who's charged with burglary of a vehicle. Then that means that you can't be fair. Does everyone understand? So my question to you about fairness, in this case, will you be able to listen to whatever evidence that's presented to you? And if you come to a decision, if you can, will that decision be based upon the evidence that you hear? Is there anyone who can't do that? Okay. Now, there are two phases to a criminal trial in Texas. The first phase, people call it the innocence phase, but it's really not. The first phase is simply, did the state prove their case or did they not prove their case? If they didn't prove their case, that means that's not guilty and there's no phase two. If they did prove their case, then there is a phase two, and that's called the punishment phase. Does everyone understand? Okay. Now, if someone is found guilty of capital murder, there is no punishment phase because there's an automatic sentence that's associated with that. Does everyone understand? And when we say capital murder, this is not where it's a death penalty case. Does everyone understand? All right. So with regards to punishment, in a capital murder case, as I said, if someone were to be found guilty of capital murder, there isn't necessarily a punishment phase because there's an automatic sentence related to capital murder. And this is not a death penalty case, so it's not death. Does everyone understand? Now, sometimes people may end up being convicted of something that's maybe lesser than capital murder. The only thing that you need to know about ranges of punishment is that in Texas, there are laws that tell us what the range of punishment is for offenses. Does everyone understand? Or hypothetically, if somebody were charged with a murder, the range of punishment is 5 to 99 years or life in prison. Now, when you think about it, that is a wide range, right? It's 5, 6, 7, all the way up to 99 years, all the way up to life. When you think about ranges of punishment, the only thing that everyone is concerned with is that, one, you internalize and know what the range of punishment is. Does everyone understand? And that you consider the full range of punishment. And usually, jurors will say, I don't know, I need more facts. And really what they're saying is like, I want to know the facts of a case before I can say I can do A, B, or C. Does everyone understand? But what you need to be able to do is whatever facts are given to you, if you were to find somebody guilty of any offense, if there are certain facts that are given to you, are you able to take those facts and make a decision after considering the full range of punishments for somebody? Does everyone understand? Is there anyone who cannot do that? The next thing I want to talk to you about is time constraints and travel arrangements. I anticipate that this case will probably be completed by next week, right? Is there anyone who has some sort of time constraint or travel arrangements that is going to interfere with that? If you do, raise your card. And when I call out your number, lower your card. So 20, 45, 51, 54, 74. All right, so everyone, and 15. All right, anyone else? All right, you can lower your card. I'm sorry, is there a card over here? Okay. All right, juror number 15, what's your time constraint?
I have the appointment on the 8th, but I have to schedule months in advance, so I believe that.
All right, thank you so much. And I know everything is going to go well with that. All right, number 20.
I have my uncle's funeral on the 9th.
I'm sorry to hear that. Thank you. Number 45. See, y'all are not standing. All right, we're going to pretend that didn't happen. We're going to start over. All right, number 45.
Pick up from my father. And he has doctor's appointments all week.
All right, thank you. Number 51.
I just received a position due to a death. And I'm a high school art teacher, and this is my 3rd week, and we have a big benefit coming up this Saturday. I'm terribly nervous. I apologize for telling you.
No problem.
So needless to say, it's a high school, Henry Ford Academy, the Alameda School, for doing a big benefit this upcoming Saturday. So we've got projects going, and I'm just nervous.
Oh, don't be nervous. All right, thank you. Number 54.
Contractor by trade, and I have a big job coming up next week that starts on the 7th, and I have to be out of town for that.
All right, thank you. Number 74.
I have a doctor's appointment on the 7th. 8 months ago.
All right, thank you. Anyone else? Number 35. Now that nothing happened to y'all, now people are coming out of their shyness. All right.
My phone, see what the calendar said, I'm
All
sorry.
right, yes.
I have a doctor's appointment on the 10th. And I'm waiting almost 3 months for this appointment.
All right, thank you. Anyone else? All right. So
I believe you're on number 66.
66. I'm sorry, when? All right, thank you. All right, anyone else? All right, so before I turn it over to the state and the defense to speak to you, I have 2 stories that I'm going to tell you. Both of these stories are true. Jury duty. I always tell people when I speak to jurors downstairs and I'm qualifying them, I always tell them jury duty is an inconvenience. What do I mean by that? Number one, you have to figure out how to get downtown. Unless you work downtown, there are so many one ways. And then you're trying to rush to be there at 8 a.m. And there's always traffic in San Antonio. There's always someone who has a car accident and it's just a fender bender and they won't move it to the side and it slows traffic down. And then in your mind, you're just looking at the time pass by. And then when you finally make it downtown, you see the building that you're supposed to be in, but you're on a one way and you can't make that turn. And then you start thinking to yourself, well, there's no traffic. If I make that turn, is that going to be okay? But you all are great drivers since you got your tickets. And so nobody makes that turn. And then you finally make your turn, you arrive and you're rushing and it's hurry up and wait. So I know it's an inconvenience. And this is why I say that it's an inconvenience. Because for me, this is a sacrifice. My family grew up in Grand Canyon, Louisiana. And my uncle was super intelligent. All the teachers knew all of their students. And they would just pass him to different grades. They would tell my grandmother, they would say, Miss Lane, we've taught him all we can teach him. And they pass him to the next grade. Now, of course, when his sisters and brother end up coming to school, they didn't like that so much because the teachers were like, we're expecting a lot out of you because of your brother. So my uncle graduates, and when he graduates, Vietnam War breaks out. And he asked for my grandmother to sign so that he can go to Vietnam. And my grandmother really doesn't want to, because if you can imagine, that's her firstborn. And I know parents say they don't have favorites, but hey, it's a firstborn, right? And he tells her, I'm just going to go ahead and go because of civil rights and other things that are going on. There's no way I'm going to be able to improve my lot in life. So she signs for him to go. And for the young people, one, majority of the people in the United States in that time, nobody even knew where Vietnam was. My grandmother had a 6th grade education, but she was super intelligent. She taught me how to read and write. And so when I started 1st grade, I already knew how to read, write, tell time because of my grandmother. So she was intelligent. But this whole thing, young people, where you have 24 hours of TV, it wasn't 24 hours of TV. It was 3 stations, ABC, NBC, CBS, and you really couldn't count on NBC because the weather had to be just perfect. And TV, you didn't get the flip, oh, let me see what's going on. No. At a certain time, broadcasting ended, and you knew it would end because they would play the national anthem and the flag just blowing in the wind. That's when it got high tech, when they would have the flag blowing in the wind. Before the flag would blow in the wind, it would just be white noise. It's like it's done for the day. This whole thing where you all have computers and you can send emails, no, it's you write a letter, you put a stamp on it. This whole thing with cell phones, imagine your life without a cell phone. There was no cell phone. My grandmother did have a phone, but it wasn't touch tone or rotary, which young people, I know you don't know what that is, but it's a phone with numbers on it. Her phone didn't have any numbers on it. You just pick it up, the operator would answer, and you would tell them who you would want them to put on the line. That's why they had songs like Beechwood 45789. So my grandmother, all she had was his number and of course his name. And when I say it's number, it's the number that they give you in the military. And she would write him a letter and wait for it to come back. My grandmother quickly learned that you do not want people from the military knocking on your door because that wasn't a good sign. So I tell people that story to say, that's a sacrifice because that's her firstborn that she's sending off to war. And she don't know if he's going to come back or not. And she's not getting messages from him daily. So your country only asks 2 things of you. They ask you to pay your taxes and jury duty. That's it. And raise your hand and raise your card, if you've ever sat on a jury trial before. That's not even 1/10 of the people in here. So that means that your country is not even asking you to come up for jury duty every month, every 2 months, every 3 months. It's usually probably once every 2 years. You can lower your hand. So I always tell people, Veterans Day, 4th of July, Memorial Day, people are always waving their flags. We love America. So I'm telling you right now, and I tell everybody, you love America, you want to serve your country, this is what jury duty is for. They're not even drafting anybody. So you don't have to go into the military unless you want to go to the military. And I used to stop the story there, but then my staff started saying, Judge, you didn't even tell them what ended up happening. Did he come back? Because they didn't even know he came back. So I told them, yes, my uncle did come back from the war. My grandmother did see him when he came back from the war. They've since passed, and some of his other siblings have passed as well, but he did make it back. But I tell you that story to let you know that jury duty is an inconvenience. Second story I'm going to tell you is that one of my friends, we went to law school together. She decided that she wanted to practice civil law. I always wanted to do criminal. So one day she has jury duty and she says to me, let's have lunch. I'm like, great, we're having lunch. And I said, how is jury duty coming along? She said, fantastic. Now that I'm judge, I'm like, how can it be fantastic? You were not having jury duty with me. But I tell her, I said, what do you mean it's fantastic? She's like, it's like when we're in law school. I'm on the back row. I'm not saying anything. So I'm not going to be selected. I laughed. I was happy. She wanted to know why I was so happy. I said, because we're going to be able to have lunch all week. So other than raising your card saying, please allow me to sit on this jury, the easiest way to be on this jury is if you say nothing. So the state and the defense will speak to you. Make sure that you speak to them and raise your card if you have questions, because this is the only time they're going to get a chance to speak with you. Does everyone understand? All right, last question before I turn it over to them. Is there anyone here, English is not your first language? Raise your card. Oh, you can turn them around. Yeah. All right, 16, 17, and 36. Number 16, what's your first language? All right, have you been able to understand everything? All right, 17. All right, thank you. 36.
Mandarin, yes, I understand.
All right, thank you. You're the first person we've had who speaks Mandarin. I thought I would end up in Louisiana, so of course I took I thought I would live and die there. So of course I took the only language that I thought would be appropriate, which is French. And then somehow I end up in Texas, but I'm learning. All right, does anyone need a break before I turn it over to the state to begin voir dire? All right, state, let me know, number 24. All right. Oh, no problem. All right, everyone. All right, everyone, please be seated. All right, ladies and gentlemen, before I turn it over to the state, I just want to let you know, if you see anyone coming through that door, it's because they didn't read the sign on the outside that says we're in jury trial, do not enter this door. It has nothing to do with this case. And when you see people coming through that door, that is staff or either someone else that needs me to sign paperwork, but none of that is related to this case. Does everyone understand? All right, state, are you prepared to proceed?
Yes, Your Honor.
All right, you may proceed.
Thank you, counsel. Hi, ladies and gentlemen. How are y'all doing today? I'm going to try to speak up because I know that I'm hard of hearing. And I know in the back it might be sometimes difficult to hear me. One, I want to tell you, thank you very much for being here today. Not everybody always answers their jury summons. So you're part of the fabric of our society that I think that a lot of people sort of miss out on. The reason being is that, I mean, in all honesty, my mom years ago, she's 84 now, but years ago, she called me up and she goes, hey, Jason, I got a jury summons to come down for jury duty. And I was like, oh, Mom, that's great. I've been doing this for a long time now. And I was like, hey, you can come down and you come down to the courthouse. I'm going to tell you what's going on. I can, hopefully you get on a jury. And I went through the whole thing about how great our system is. And, I went to law school for this. You remember when, and I talked about it sort of extensively. And as I went on, I could tell she was getting a little bit impatient. She goes, well, okay. And she kept on saying, okay. And then she goes, but I have a question about it. And then I go, what is that, Mom? And she goes, how do I get out of it? Okay. So that's how a lot of people feel about it, right? I mean, that's how almost everybody gets out of the mail goes, I'm busy that day. I got my kiddo at school. I got kids at college that I got to take, or I got a job that I can't miss a deadline. And I'll tell you this, I think all of us feel that way at times. And I'll tell you this, I sort of like comparing it to a right to vote. How many people here have heard, like they put it everywhere, rock the vote, make sure you vote, make sure you get out there and vote. You get it all the time, right? Every single time election comes around, vote. Well, one of our founding fathers of this nation said that the right to sit on a jury of your peer is more important than the right to vote. I mean, that sort of puts it in perspective for you. There's no other system in the world that does this, that allows your peers to determine your liberty or freedom. And that's the importance that we're looking at today. Because there's no ifs, ands, or buts. A person's freedom and liberty is at stake. And that's how serious this can be. So yes, you'll see me up here, I'll smile, I'll make some jokes. But just remember the seriousness that we're here for today. For probably the next week or so, one of 12 of you will be here determining that. It's a little bit of time, like the judge said, that our country asked us to do a little bit more, but it's only going to be like a week or two. And can everybody here safely say that, hey, even though I may not want to be here, even though it's going to be a burden on me at times, I'm going to put all that aside and sit here and listen to the evidence that comes in up on that stand and determine whether the individual is guilty or not guilty. Can everybody promise that? Does anybody here say, hey, look, I appreciate that. I'm glad you did your little speech, but I just can't do it. I don't want to sit here. I can't sit here. I have something on my mind that I'm not going to be able to do it. And this is the time. All right. This is the time for y'all to determine if you can be a fair and impartial juror and will follow the law. That's all we're asking. You listen to the evidence that comes in. And at that point, at some point, you go to the back of the jury room and you deliberate with the other 12 jurors or less jurors, and you determine whether the person is guilty or not guilty. I like to say this, and I don't know if anybody here is going to catch this, if they can tell me the movie this came from. It's my time, and it's your time. Isn't it really our time? Anybody? Number 50? Okay, number 50 said Fast Times at Richmond High by Spicoli, right? He was just like, well, it's our time, right? And you know what? That's what this is right now. This is our time, okay? This is really our time as defense counsels and prosecution to ask you questions. And guess what? Since it's our time, you can ask us questions at any point. If you have a question, you raise your hand, you're like, hey, or if you say, hey, I have a bias. I don't like short little white guys that are bald, right? Okay? I mean, there are people out there that don't like people like me. I want to know that. If you have some bias, because it could be easy as, I like ice cream more than I like birthday cake. That's a bias. It's a prejudice, okay? So keep that in mind. We need to know that. It's really difficult for an individual that gets on a jury and sits over here and they forgot to tell us something. And at that point, once you're sworn in, you can't talk to us anymore. You have to sit there and wait, deliberate, come up with a decision of guilty or not guilty. So that's the importance of this, okay? Does anybody have any questions right now? No? All right. Like the judge said, I'll go over this very briefly. Jury selection. This is jury selection. This is where we're getting information on you and letting us know what you know and how you feel about certain cases. In this particular case, it's a capital murder. Then, once you're picked, again, the guilty or not guilty phase, and then the punishment phase if there is a guilty. If there's a not guilty, it's not guilty and there's no punishment phase. This is a capital murder. Again, there's the first phase is guilty, not guilty. Second phase is the punishment, which again, if it's capital murder, you would not play a part in. Is everybody okay with that? Does anybody sit here saying, if I say guilty, I want to sit on the punishment, I have to. Does anybody feel that way? No? Okay. Elements of capital murder. These are the elements. And let me just reiterate, I'm not going over any facts or any things that exactly relate to this case as in the actual facts. Anything I talk about right now or defense counsels talk about is all hypotheticals and examples. Again, not talking about any facts of this case. We can't at this time, okay? These are the elements of capital murder. There's a certain date in Bexar County, Texas, a defendant intentionally knowingly causes the death of a victim by shooting that victim with a deadly weapon while committing or attempting to commit a different felony, but I put robbery in there. It could be other felonies, but I put robbery. Does everybody have a chance to sort of soak that in? Okay, these are the elements. This is what we as the state have to prove beyond a reasonable doubt. Again, does anybody know the definition of beyond a reasonable doubt? No, because there is no definition that the state or rather the courts give you. You have to determine that on your own reasonableness and your own common sense. Since I hit on common sense, don't leave it at the doorstep. Remember that. Your common sense is what you use to determine things in your life. Sometimes you get caught up with the technicality or something like that. Use your common sense. You determine that whether the evidence is believable and truthful. You, as each juror, determine whether the state has proved a date. Now the date could be on or about, say, January 1st, 2025. Okay? So that around that date that this capital murder was committed. That's an example. In Bexar County, Texas. Bexar County, Texas, we have to put that up because the fact is, jurisdiction-wise, that means it happened within the confines of this district, which is Bexar County, that this capital murder happened, okay? We go on forward, and the named defendant intentionally causes the death of the victim. We have to prove all those. Now, some people will say, hey, look, we go back to back and the state forgot to say the date. Or certain, and how do we prove it up? We prove it by some officer or some person, a witness or somebody coming in going, yeah, it was on January 1st, 2025 when this all happened. So let's just say we go through this whole trial and we don't prove that up. And we just miss it and we don't go over it and we never hear any testimony that this happened on January 1st, 2025. Juror number one, I'm using numbers, it's easier. If you go back to deliberate, what would you do? If we didn't prove up one of those elements, particularly the date. What were your verdict? Not guilty, right? Who thinks that's a technicality? Anyone? I mean, it's sort of technical, right? I mean, it's easy to say that, but that's our responsibility to prove that up. And exactly right. Does anybody disagree? Say, hey, just because y'all didn't prove up the date, you proved up everything else. That this guy shot this victim with a deadly weapon while he was committing robbery. And you know what? You just didn't do the date. Does anybody here say, oh, I'm still going to say guilty, even though you didn't prove up all the elements? Anybody? Number 69? Okay, thank you. Thank you. And you're saying that you would say, hey, the date is just a technicality, and I'm still going to say guilty. Is that what you're saying, sir?
Yes, sir.
Thank you very much, sir. Now, yes, sir. What's that?
I would say not guilty.
You would say not guilty. Exactly right. And your number, sorry, 17. You would say not guilty because we didn't do our job, right? Okay. Thank you. And you hold us to that burden. Here's a definition of intentionally. or with intent with respect to the nature of his conduct or to the result of his conduct when it is his conscious objective or desire to engage in conduct or cause a result. I like definitions. I just put it up there because, how do you prove somebody's intention? I mean, number 3, if I come over here and grab that card out of your hand, did I intend to do that? Probably. Yeah. Like I'll walk over here and I go, give me that. Did I intentionally do that? Yeah, I did. Right? So the fact is, common sense. If you're doing something and you.
Your Honor, I'm going to object. That's just a rephrasing of an impermissible presumption.
All right, that'll be overruled.
And so that's just one of the definitions. Remember this, ladies and gentlemen, you're not going to remember all these definitions because at the end of the trial, when we send you back to the jury room to deliberate, there'll be what we call a jury charge. And you will get definitions in there that the judge feels that is appropriate, that needs to be going to the jury room with you. So you don't have to memorize anything. You just have to listen to the evidence that comes, or and the testimony and the evidence that comes in on that witness. Okay? And how do we prove intent? Words and actions, right? Exactly what I did right there. My actions were, think it's from you, right? So you can use action and you have to use word.
Your Honor, I'm going to renew the objection. I have questions.
Yes.
Bottom portion of this is motive is not necessary and not an element. And those elements that I listed earlier, it didn't say, why did he do this, right? Or why did she do this? And motive, a lot of times we would like to know what the motive is, right? And in this particular type of case, a capital murder, we would like to know why somebody chose to commit capital murder, right? It's just human nature. I want to know. I want to know more. I mean, how many of y'all, and just quickly, how many of y'all watch anything about CSI or anything on TV about like crime or true crime or anything like that? Okay, I mean, that's the lion's share of people, right? I mean, there's some of these cases where you got a bird that landed on a dead body and then flew off 20 miles and landed somewhere else, and it had some blood on it, and somehow that a nurse saw it and said, that's blood, and took it over and determined that that was the blood and DNA of somebody else, and, very outlandish stuff. Some of it, obviously could be true. It happens, right? It's that true crime mentality. And like, it goes through this whole definition, not that definition, but explanation of what happens, right? Of all the different intricacies of, say, CSI, and then the police work and everything else, and witness testimony and videos from a satellite that shot down. I mean, some of these shows are so over the top that it sort of takes a high burden, right? People expect that. Does everybody expect that in any case, or how do y'all feel about that? Number 2, how do you feel about it? You believe it's important? Do you think that, say, CSI Miami, some of those shows could, they're sort of, you don't watch it? Okay, all right. Does anybody watch right here? Anybody CSI, anything like that? Number 5, how do you feel about it? Mhm. An idea. Right, an idea, almost a perfect idea, right? It's perfect. And number 7, how do you feel about it?
The same, I sometimes I feel like for drama purposes.
Right. I mean, do they seem like reality?
A lot of them, I believe the majority, yes, but a lot of them I feel like this is a little bit high.
Well, I mean, you feel like producers make it a little bit more spicy. They say, hey, we got to put this in there. Otherwise, nobody's going to watch, right? I mean, we got to put in that. We got a video camera from, a mile away that happened to catch a little corner here, and we were able to digitize and everything else. And all of a sudden it looks like, and I can see who the person is, number 18, I can see you right there. It is perfect from over a mile away, right? I mean, I guess, we all see that stuff on TV about where they have the satellites that can read a newspaper on a corner in New York City. You think that is like, say, a security camera from Walmart is gonna have the same capabilities? What do you feel about that, number 18?
I've seen it.
You see?
Yeah, I've seen them before when they instantly
Mhm.
zoom into your ID or phone or whatever.
Right.
Actually, just pick up the picture and
Exactly right.
whatever they want to catch other people to.
I know you're exactly right. Now, let me ask you a question about that. How many people have seen the Ring cameras that people have on their houses? Right? Almost everybody. Who has a Ring camera on their house? Quite a few people, all right? Number 21. Have you ever gone back to your Ring camera and looked through it to see how that happened in your yard?
Very much.
Very much, okay. And tell me this. Every time something happened in your yard, does it pick it up,
Not every time.
right? And why is that, do you think?
Sure, I think it didn't get to the right part where the sensor is, or
Yeah. Well, I mean, you're exactly right. Not every time, right? Does everybody else sort of fall into that category sometimes? Where you're like, sometimes I go, I know I walk by that camera. Why doesn't it show me walking by that camera? Well, sometimes the sensor doesn't pick it up. Sometimes it's too quick. Or sometimes I see it on my Ring camera. It comes up with that notification, and all of a sudden you look at it and you're like, what's going on my front door? And then you don't know what happened, and there's nothing there. But then all of a sudden you put the audio on, if it has audio capabilities, and you hear that car that drove by, right? So it picked it up, but it was too fast, and it didn't get picked up on the camera, right? So there's a lot of different intricacies about this type of thing. But going back, to sort of got off base there on my Ring camera, but motive. I know we would all like to know what motive is, but is everybody here saying, hey, look, I would love to know what the motive is, but no, it's not an element. Does everybody agree with that? In fact, I'm going to ask you a question. It says, if you believe all the elements beyond a reasonable doubt, would you be able to find the defendant guilty even without knowing the motive? 2 is agree, and 1 is disagree. I'm going to start right over here in this section right here. And I'm sorry, those little clickers, those belong to defense counsel. Those are for my questions. Unfortunately, the state, we don't have those. Okay, so I'm going to be asking you the question. All I'm going to ask of you is if you raise your card when I ask you that question. First, that question, I'll say, who up here disagrees with that question? Who disagrees? Raise your card, please. Number 6 disagrees.
I understand, for me, knowing the motive, it's generally what drives people to do anything. Whether it's purchasing a car, whether it's choosing your career, choosing your job, you gotta have some sort of motive. What would drive you to do whatever you're gonna do in life?
Exactly. I mean, yeah, that's, human nature wants to know, right? But knowing that the law is that you don't have to prove motive, you know that's the law, right? But since you feel so strongly that you want to know motive, that you would not follow the law.
I'm following the law, I just find it very difficult. For my nature, I think things pretty logical.
Okay.
So,
You want A, B, C, and D. You don't want A, D. You want the B and the C, right?
yeah.
Anybody else agree with that? Number 16. Okay, I'm gonna go back through this in 1 second. Well, up here, number 12. I'm sorry, at least 12, 14. Everybody else agrees? Is that right? Okay. Let's go over here. And I'm gonna go by the first couple rows here. Who disagrees? Number 1, who disagrees with what's up there right now? Number 15, 16, 17, 19, and 22. Okay. All right. And 23. Okay. 24, 32, 32. Okay, 1 second. 24, 31, and 32. Okay, thank you. And anybody else in the rest of this section over here disagree? Number 48. Thank you. Over in this section, this whole section, anybody disagree? Disagree. All right. So right now, everybody else that did raise their number agrees with that. Say they will follow the law. Okay. Thank you very much. Remember this, the judge went over it pretty well, not well, very well. Sorry, Judge, not this is the judge. She went over it a little bit, but it's in my board. I like going over it again because that's how important important it is. The state has the burden. It never shifts over here, ever, ever. It's always on us. If I don't do my job, if Megan doesn't do her job, you go back there and you say not guilty. I don't care what it is. If it's a technical, the technical element, you believe it or not, it comes back not guilty. Does everybody agree with that? Except for number, I know that we got over there, but everybody else agree with that. I want to go over it twice because it's so important. All right. So remember this. I'll hit on this again about the defendant testifying. He does not have to testify. He or she does not have to testify. You cannot hold it against them. Like the judge said, there's 1,000,001 different reasons why a defendant would testify. And one of them I just hit on. We don't prove our case. Why would you testify? Why would you risk it? That's one reason. He stutters or he makes up, he just can't handle the pressure, or she can't. Gets red. Sometimes sometimes I get mad if my ears turn red, or it feels like I have flames, you see the streaks on my head. So, certain things, anxiety, many different reasons, many. So everybody promises, not only promises, says they will not hold it against him if he does not testify. The judge hit on it. It's beyond a reasonable doubt. You have that definition in your mind. It's up to you about that definition of what you believe beyond a reasonable doubt is to you. And it's not beyond all possible doubt or a shadow of a doubt like the Perry Mason stuff. It's beyond a reasonable. Remember, reasonable doubt. How do we prove an offense? Physical evidence and witness testimony. Let's go over physical evidence. Let's go. I think have I bothered you getting up the third report? No. Here I am. Number 4. Tell me something, and in a case like this, capital murder, what do you feel that might come in as evidence, physical evidence? Like a capital murder, yeah.
Yeah.
Yeah. A person. Okay, somebody being hit like this, like a person's body, because it's murder, right? We got a body. All right. Okay. Okay. There. Okay. And some people don't like speaking in public. I understand that. I mean, I used to be the same way myself. At 6, I talked to you. 7, I talked to you. Let's go over here to number 8. Sir, what do you think of the physical evidence that would be coming in here in the trial? Weapons. There could be weapons, right? Now tell me this. Brought up weapons, obviously. Why would a weapon not be coming in? Can you think of a reason why? Well, let me ask you a question. And this is a hypothetical because I know you won't do this. Let's just say you stab somebody intentionally, all right? And let's just say anyway.
I'm going to object. I think that this is a proper commitment question,
Okay.
despite being called a hypothetical.
All right, if you'll re-ask your question, and then I'll make my ruling.
I'm going to phrase it like this. I stab somebody, okay? And what do you think I'm going to do? And I intentionally did this. And I didn't have any justification. What do you think I'm going to do with that?
I'm going to renew my objection to the improper hypothetical.
All right, that'll be overruled.
Exactly. That's what I was getting at. Sorry, I didn't mean for you to stab somebody. So, but the fact is, I'm going to throw it away, right? I'm going to get rid of the murder weapon. I'm not going to be like, well, leave it right here for everybody to find it, right? So that's a very good example. So that's an example where what you think weapons will come in, and that's logical. But then one reason that it did not come in is because maybe you got thrown away. Right? Number 8, physical evidence. Oh, I'm sorry. Number 9. Thank you. What physical evidence? What do you get? What? Location. Okay, like a physical location. This is where it happened at. Okay. Number 10. And sometimes you got DNA, right? If somebody stabbed or something like that, you might have some of the blood, or you might have hair fibers or something like that. You million different things that like trace evidence, right? Number Okay, number 11, what about any other physical evidence?
I'm sorry, other than what was said, I can't think of anything else.
Okay, all right. And number 12?
I'd say like, video.
Video. Okay.
Video cameras everywhere.
And I hit it on it earlier, right? Talk about ring cameras, talk about security cameras, talk about Walmart, stuff like that. So sometimes you would see videos come in a case, right? Do you think every case has a video? I mean, do you think every video that comes in is perfectly clear and you know, the person committed to the crime right in front of the video?
Actually, it's video, so it doesn't. As many cameras as I put in, sometimes they don't see.
And I mean, and sometimes the camera, I mean, tell me that sometimes you install cameras, but it's for a different purpose. It's not to catch a crime. Sometimes it's just to watch employees like at Walmart or you know, watch the back door of a restaurant or something. So there's many different reasons why things are installed. But like you said, there's many cameras, many different places. Is that right? And number 13, okay. Number 13, what about you? What about yourself? What about any other physical evidence you think that might be coming in? Fingerprints, right? Now, speaking about fingerprints, do y'all think if I come up here and touch this right here with my thumbprint and I walk away, do you think my fingerprint's gonna be there? Just need to speak out, sorry for the.
Maybe if the scene was investigated or something like that.
Right. Well, I mean, and sometimes there's surfaces that like, for instance, there's a grade on this. And, you know, it won't pick up fingerprints possibly, right? I mean, sometimes you can see somebody grab an object and then you can dust it for prints or whatever it may be, however the CSI would do it, and it won't come back. Or it might be smudged, right? You've ever seen your cell phone? I think everybody has a cell phone that's sort of with the screen. You ever see that screen and it looks all smudgy? And you get a napkin and you sort of, or you get your shirt and take it off because you're getting rid of those smudges on there, right? And those smudges are your fingerprints just sort of going on it, right? So a smudge may not be able to be a readable, legible print. Do you agree with that? Does everybody agree with that? Everybody? Okay. And number 14.
Shoe size.
What?
Shoe size.
Shoe size. That's right. I mean, you know, I'm just like O.J. Simpson trial, right? Where there's shoe prints and everything. So yeah, you're right. That's another physical type of things that could come back. Other things that could come back are numerous different things. You know, we got what was called gunshot residue. Has anybody heard of that? Has everybody heard of that? Pretty much. And gunshot residue, number 15. What do you think gunshot residue is?
It's the gunpowder, like the smaller gunpowder molecules that are released when a firearm is fired.
That's pretty good. I mean, it's pretty straight on. It's the primer, you know, that comes out, and it pretty much those little dust particles float around. They land on you. And do you think that if I shot a gun, it would be on me or my hand?
It might.
It might. What do you mean it might?
Smaller particles might, there might be. Like something that's not visible to the naked eye.
Okay. And do you think, let's just say I grabbed a gun, I was playing with a gun. I never shot it. But do you think the gunshot residue could be on you?
Perhaps if it was recently fired before.
You know, I'm gonna rescind my objection to improper commitment questions. I don't know what this hypothetical would do to either help exercise intelligent peremptory or strike for cause. It's just a prelude to a fugue. We're just essentially testifying about information about gunshot residue to the entire denier.
All right, that objection will be overruled.
Exploring the idea of gunshot residue, right? Let's go on. Let's go on to witness testimony. I think I'm on number 16 now. Sir, what do you what type of witnesses would possibly come in on a capital murder case? Neighbors, like just like next door neighbors that it happened next door. Okay, that's like a witness. Number 17, innocent bystanders. Somebody just say, well, I mean, I guess neighbors and innocent bystanders. Yeah, like you're out at somewhere. Okay, all right. Number 18. That was there. Like a what?
Someone that took part in capital murder.
Okay, somebody that took part.
And I didn't get in trouble.
Okay, well, you're saying, tell me if I'm wrong, somebody that played a part in the capital murder? Okay, so like, I guess what we would call like a co-defendant. Somebody else that may have been charged. Okay, number 19. Okay, okay, we're all hitting on lay witnesses, what we call lay witnesses, right? So those people are maybe somebody that's an innocent bystander that just happens to see what happened, right? Okay, number 20.
The actual, victim.
The victim? Okay, well, capital murder. I mean,
Well, that's true.
but you're
I
right.
don't-
You're
I
right.
don't know if the victims.
If they survive, if they survive.
Just like that.
Okay. All right. Number 21,
Coroner.
a coroner, an ME, sort of hitting on the victim. The ME would be somebody that would come and testify about the victim, right? Like a medical examiner. All right. Number 22. And I'm sorry, you just need to stand up when I call on you because for the court reporter, as the judge said. Number 22. Exactly. You know, police officers should come in, right? Number 23.
I have no idea.
All right. Well, you know what? Number 24. Do you have anything?
Well, if you have a camera out, like a door cam or a camera like in the stores or in it, whatever, if the camera picks up someone in that area at the time of the murder or whatever, they could probably find that person.
Okay, the person that had the camera.
Yeah.
Yeah, that's diving deeper. I like that. I like that. 25?
What they said,
All right, thank you, sir. But, well, I guess what it comes down to, that's evidence that would be coming into this type of case, that would be coming up here in front of the jury, and then the jury determines the credibility of that evidence. The jury is really the judges of the evidence. Keep that in mind. Judge is more like a referee. Like when you heard objections, you know, we stop, we talk to the judge, and then she overrules or she grants that. And so the fact is that you as a juror, if you're sitting over here, you will be the one that judges the credibility of that evidence that comes in. I'm going to ask you this question, and everybody just go ahead and read it to yourself real quick. What is your opinion of the criminal justice system? Number one, it's terrible. It takes away our rights. Number two, it's concerning. It interferes with our rights. Number three, it's helpful. It looks out for our citizens. 4, beneficial. It protects us from harmful actions of others. Give a second for you just to sort of read those. Then I'm going to go through and ask, I'm going to ask this section up here first, the 14 of y'all. Who out of here agrees with number 1? Please raise your card. Number 5. Okay, I'm sorry, did you raise your card? Okay, number 5. And then who agrees with number 2? Raise your card, please. Number 3. And I'm going to keep them up, and when I call your number out, please just lower it. 1, 3, 6, 10, and 14. And then that's the number 4. Who agrees with number 4? Okay, we got number 4, 7, 8, 9, 11, and 12. Thank you. And same question. I'm going to ask, I'm going to confine it to the first 2 rows, and I'll do 2 rows and 2 rows. Okay, the first 2 rows. Who agrees with number 1 from up there? Please raise your card. Number 2. 16, 19, 22, 28. Your number, okay, I'm sorry. For number 1, number 24. Thank you, ma'am. The next 2 rows. Did I miss? I forgot 4. Yeesh, I'm losing it. Okay. For number 3, please raise your cards. 15, 18, 20, 26, 27, and 29. Okay, thank you. Please raise your cards. For number 4, number 17, 23, 25. Thank you. Thanks for catching me on that one. Okay, these 2 rows right here. Right here, just these two rows. Please, for number 1, please raise your card if you agree with number 1. Number 32. Okay, you agree with number 2. 30, 33, 35, and 42. Thank you. You agree with number 3. 31, 34, 36, 37, 38, 39, 40, 41, and 43. You agree with number 4. Okay, thank you. The last 2 rows. You agree with number 1. You agree with number 2. Number 50. Thank you, sir. You agree with number 3. Okay. Put your card down. You agree with number 4. 47, 51, and 55. Everybody else was number 3. Make it a little bit faster. The first 2 rows right here. You agree with number 1. You agree with number 2. 59, thank you. You agree with number 3, 57, 60, 61, 62, and 64. You agree with number 4, number 58 and 63, thank you. The last 3 rows right here. Agree with number 1. You agree with number 2. And that's 69, 72, 73, and 74, thank you. You agree with number 3. That is 65, 67, 68. 70, 71, and 75. Thank you. And you agree with number 4, number 66. Thank you. Now, I'm going to move on from this subject and let's talk about law of parties. We sort of discussed it. Number 18 sort of brought it up, a co-defendant, right? That's what in the state of Texas we call law of parties. Definition of law of parties under Penal Code 7.01 is a person is criminally responsible as a party to an offense if the offense is committed by his own act or by the conduct of another for which he is criminally responsible or by both. A lot of legalese, I guess, in there, but it's co-defendant, right? That's what a co-defendant is. And we're going to sort of hash out and talk about that a little bit more, okay? You're criminally responsible for an offense committed by a product of another if acting with intent to promote or assist the commission of the offense, he or she solicits, encourages, directs, aids, or attempts to aid the person to commit the offense. And that last part there is it can be before, during, and or after, or the whole time. So let's sort of talk about this a little bit more. These are my examples that I like sort of using. For capital murder, say I have a gun, I go into a store. Megan and I decide that we're going to take over to 7-Eleven and not have to pay for our refreshments. I have a gun, she doesn't have a gun. But we both go in with the plan to take what we want and leave. She knows I have a gun. She knows what the plan is. We go in, stealing it. They try to stop me. The clerk tries to stop me. I shoot the clerk. We run away. Number 3. You're number 3. How do you feel about that?
What you want to do? Or- She knew you had a gun, didn't she?
Right. But she knew I had it going in, right? She knew what the plan was, right?
Did you find it?
Had a gun. It's sort of difficult, right?
It is.
It's not the easiest thing in the world.
I should have been looking for. That's what I'm gonna tell Megan right there.
That's true, that's true. But it's an example.
But I mean, when you run with people like that and you don't know what they're gonna do.
Right.
Get us tempted.
Right, you take a gun with you, we're gonna go, rob this place. And then I take out the gun and she knows I have a gun. And boom. You know, don't get me wrong, maybe she's not the one that pulled the trigger. I did, right? Right, she didn't stop me either, but then what did we do after I shot? We ran off, right? We ran away,
Well, that would be it.
right? She didn't come forward, I mean, let's just say she didn't come forward. So that's a scenario, right? Let's talk about a scenario where she doesn't know we're gonna go in there and have, you know, I have a gun. Say I have a gun, she doesn't know I have a gun, we go in there to steal though. So then I take out the gun, I shoot the clerk, and then we run off. How do you feel about that? She didn't know I had a gun at first.
Correct.
Right, because that's an after portion, right? She ran out after. She's part of it. That part, right? Get in the car, we take off. Right? Who feels like, hey, whoa, no. You know, I don't know. I don't like that feeling. I don't think that's a good scenario. Anybody feel that way? Number 5 and 7, 22 and 44. Thank you. And I haven't talked to 44 yet. So, sir, if you don't mind standing up, how do you, just tell us your feelings on that.
Because here, everyone can open carry a gun. I walk in the store, when a person walks in, this one, they're carrying a gun. I don't know what they're planning to do.
Mhm.
And if he or she robbed the place, I'm out.
Okay.
So they can carry a gun in the store, and I don't know what they're going to do.
Mm-hmm. Mm-hmm.
So
Okay.
everyone walking around here carrying a gun. When I see you walking around carrying a gun, I'm like, why is this person carrying a gun?
Yeah.
And I'm automatically saying, I see he or she carrying a gun.
Okay.
So they can carry guns.
Okay.
So
Thank you.
it's not always they're going in to rob.
I agree. Thank you, sir. Number 51.
Sir, why wouldn't you just take his phone, go through the records, check on intent, and then you know how far the data is connected, and take her phone too?
Well, that's evidence, right?
Yeah.
That's going back to evidence. You're exactly right. So in some cases, what type of evidence comes in? Phone evidence, right?
And because she's aiding and abetting, she's aware of what's going on. So
Right.
that's,
And sometimes you won't have the phone. And why won't you have the phone?
because you leave it in the car, or you throw it out, or you do something to become disposable, and so you do something else with it, you destroy it.
Exactly right. Exactly. You destroy evidence, right? Or you get rid of it. Okay. Now, there's many other different scenarios. Like I like the drug deal scenario. Well, I'm gonna go get drugs from Megan. I'm gonna go get drugs from Megan, and I decide to take my gun with me because it's a drug deal. You know, in the movies, it's always a drug deal. You have a gun with you, right? And so when I have that gun, I go to the drug deal, but I don't like what she's doing, so I take the drugs and I shoot her. And I run out to the car with my buddy sitting in the car waiting for me. Number 6, how do you feel about that scenario? What do you think about that?
By association, you're associated with that person, so pretty good. That's good.
Well, you're the getaway driver, right? I mean, you knew you went in there for that. I mean, that's the scenario, right? How do you feel, number 11, how do you feel about that? Yeah, that's something that evidence-wise, you need to know if they knew what was going on, right? Right.
Oh, I'm sorry, it doesn't seem based on that scenario that the person knows.
Mhm.
How you said.
Like that was gonna go down. They could have been sitting in the car and you go inside, they didn't, you were gonna go pick up something. They might not know it was a drug deal, right? They might not know you had a gun on you. So that's something that evidence comes on the stand that presents to you and it's credible evidence.
15
Then-
minutes.
What's that? Jim?
15 minutes.
Okay, thank you, Judge. And so those are scenarios where you're like, you need to know more, right? You can't just have, oh, I'm just a getaway driver, or I'm sitting in the car, okay? And I thank you for your insight on that. I'm gonna probably go a little bit faster. I'm gonna go past this last example. And I think to reiterate again, you can join as a party at any time. You can join before, during the commission. Like, I didn't know what was happening, but then after he pulled the gun, I decided to help out. Right? Does everybody agree that's a scenario that's a possibility as a party? Anybody disagree with that? They say, hey, my buddy, she pulled out, Megan pulled out a gun and started robbing this guy. I didn't know it was gonna go happen, but then I sort of was like, well, I gotta help her. And so I take something from him, and then he gets shot by Megan and we run off. You see that scenario? Okay? And that's a law of parties. During and even after. You're the getaway driver, you're helping out. Okay? So let's talk about co-defendants. We talked about it, I mean, law of parties, but in the end, it's co-conspirator or co-defendant. That's sort of the lay terms of it. Testimony of a co-defendant or the party. I'm gonna ask you this question. Do you think it's trustworthy, all of it? Or you don't believe anything they say? Or are you gonna compare it with all the evidence? I'm gonna ask this first section, who agrees with number one? Who agrees with number two? Not believe it at all. Who believes that? I'm gonna compare it with all the evidence. Number three. Everybody agree with that? Okay. It's pretty simple. Does anybody over here say, hey, I don't believe, I'm gonna go to one, I'm gonna go to number two. Does anybody in this whole section say, hey, I don't believe anything a co-defendant says because they have some skin in the game? No? Everybody agreed that they're going to compare it to all the evidence. Everybody agree with number three? Okay. All right. Thank you. And same question over here. Everybody says, hey, I'm going to compare it to all the evidence that comes in and then determine whether it's credible or not. Okay. Thank you. Let's talk about self-defense. I think in most cases, a lot of times, talk about self-defense. And this is the definition of self-defense. The person is justified in using force against another when, to the degree the actor reasonably believes the force is immediately necessary to protect the actor against others' use or attempt to use unlawful force. Okay? Put that definition up so you can read it. I like reading it out loud. But remember, you don't have to memorize any of this, okay? Reasonable belief means a belief that would be held by an ordinary and prudent man in the same circumstances as the actor.
I'm going to object. That's not the entirety of the law. There's a bifurcated standard. There's an objective component, but it has to be viewed subjectively through the eyes of the defendant claiming self-defense.
All right, ladies and gentlemen, the court will give you the law. The objection is overruled. You may proceed.
In the end, I keep on saying, use your common sense. You're an individual that comes in here to determine the credible evidence that comes in. Remember, reasonable reaction, equal force. Another portion of this law states you cannot provoke the difficulty. Meaning I can't, in a sense, come over here and take number three, the juror card, and say, I'm not giving it back, it's mine now. And I'm provoking that. I'm provoking you into trying to get it back to me. I'm provoking you. I can't be provoking that difficulty. For instance, I take that card and then she comes towards me and I say, oh, pop, right in the face. I provoked her. Okay? That's not fair, right? Okay. Also, words alone are not sufficient. I could tell Megan that I'm going to come over and shoot her one day, or I'm going to shoot you right now, but I have no gun in my hand. That's words alone, right? Does anybody say, hey, if you tell me you're going to shoot me, I'm going to shoot you? Anybody say that? Number 50?
Could be considered terroristic.
Terroristic threat? Right. It could be a terroristic threat. That's a crime, right? All right. Deadly force, I'm going to go over that definition because this is a capital murder case, means force that is intended or known by the actor to cause or in the manner of its use or intended use is capable of causing death or serious bodily injury. obviously deadly force. Everything that I just spoke of applies with this use of deadly force. If you're going to use deadly force, you need to have the reasonable reaction. I think we all have heard, or I've heard at least, and numerous people have, the popcorn incident in a movie theater. Somebody throws popcorn at somebody else and they shoot him. See the reasonable reaction? Does anybody think that's reasonable? Hey, I throw popcorn at you and you shoot me? Okay. This is everything that I just went over with you previously. So let me ask you this question. Use of self-defense, especially with deadly force, must be a reasonable reaction and with equal force. Up here, I'm gonna go with number 2. Does everybody agree with that? Or just everybody agrees? Anybody disagree with that? Number 14 disagrees. Okay, number 5 disagrees. Number 7 disagrees. Thank you. First 2 rows. Everybody, number 2, agree with that or disagree with that? I'm sorry, agree. If you agree with that, raise your card. All right, that's most of you. So let me ask, who disagrees with that? Raise your card. Number 15, number 19, and 22, and 29. Thank you. I'm going to ask who disagrees with it. Who disagrees? Raise your card, please, in these 2 rows. Number 43, thank you. Who disagrees with these last 2 rows? Anybody disagree with that? Thank you. And in this section over here, who disagrees with that? Anybody disagree with it? Number 69, thank you. Okay. Number 13, yes, ma'am?
Said that he threatened him to shoot him, so he said he would shoot back. You know, so how do you determine what's a reasonable reaction to something like this?
Right, well, equal force, right? For instance, if I come over and steal your card, and then you shoot, is that reasonable reaction? Or, okay, that's an extreme example. Okay. Okay, all right. I'm going to move on to the subject of intoxication, voluntary intoxication. I mean, if I go get drunk or if I go take drugs voluntarily, it's not a defense. Does anybody think, hey, I was drunk or I was doing drugs and I was intoxicated? Well, hey, you should, that should determine that you should be not held accountable for it. Does anybody believe that? No? Anybody? It's okay if you do. Nope. Okay.
May play a part in it.
May play a part of it. Well, I mean, some of those things is that sometimes, hey, you know, maybe not they're the guilt innocence, or not guilty or guilty. Should that play a part in it? It's not one of the elements.
Guilty or innocent? Yes. No, it does. You have a circumstance.
Right.
It could have played a part in it because there are mind altering drugs that may cause him to react.
Exactly. And I'm sorry, what number are you, sir? 32. And you're exactly right. Because, like, let's just talk about like meth, right? Have you ever seen somebody on meth? If you haven't, I mean, they act very different than their normal selves, right? And it alters their perception. Yeah. Exactly right. And they go crazy and they're running around and it affects the person's normal behavior. But you can see how that could play a part in it. But for the elements of capital murder, intoxication, voluntary intoxication. What's that?
I think that should be considered.
You think it should be considered?
If the guy was in his normal state, he may not react that way.
Okay, that's exactly right. I mean, people get intoxicated and they may act differently. Thank you, sir. I'm sorry, number 20, 21?
It wasn't the victim's fault. They showed.
All right, so if you all could speak up.
I said it wasn't the victim's fault that you chose to be intoxicated.
Right.
So
So I mean, you can see how it's not the victim's fault that you were that the defendant was intoxicated, right?
What's your number, man?
21. I want to move over that. In this particular case, I just want to reiterate that if found guilty of capital murder, we are not seeking the death penalty. It would move to punishment, but it is not the death penalty. And there's no probation in a case like this. Does everybody here understand that number up here? Okay. And over here, everybody understand that? And over here. And I'm gonna ask you sort of, let me ask you this. It's not up there, but, you know, let me see. Number 10. How old is middle age? Be careful, okay? Okay. That's a middle age, you know, that's a little young. I mean, I thought it was, I mean, I'm 51, I was like, grow up. But okay, but there's an age difference, right? I mean, in this room, you have many different individuals, many different ages. Is that correct? Would we agree with that? Let me ask you, in this section, just because of the age of a person that is charged with something, would that be determinative of how you say guilty or not guilty? Okay, I'm gonna go down the road. Number 1, anybody say yes? See, number 5 says yes. Number 6 says yes. In the back row. Okay. Would age of the person that's charged be a determining factor for you on deciding guilty or not guilty?
I would ask.
12, okay, thank you. 14. Did you want to expand on that, sir?
Well, somebody needs
Mhm.
and I'm not saying I would ever consider, but I would consider, I mean,
Okay,
as a consider.
okay. Thank you for expanding on that.
You're number 12.
Yes, number 12. Okay, and this first row. Age to be a determining factor that you would use age. In this first row, number 16, number 20, thank you. This one right here. Anybody? No. All right. Number 28, okay, this row right here. 33 and 31, thank you, right here. Number 38, thank you, right here. 44, thank you, sir, right here. Okay, and then starting over here in this section right here, just row, anybody use it? Right here, here, here. To the back row. All right, thank you. Up, number 2. It's not about competence. No, no. If you would consider, okay, thank you.
2 minutes.
Thank you, Judge. Real quick, does anybody here, you know somebody that's been accused of a violent crime or charge? And I'm gonna go through right here, number 5, thank you. Number 6, number 10. 3, 4, 5, 6, 10, and 12. Number 2 and 13. Sorry, that. All right. In this section right here, anybody, like, you know somebody that's been charged with a violent crime. 16, 17, 23, 24, 26, 28, 30, 32, 33, 35, 48, 49, over here. 60, 64, 66, 69 through 73. And my time is running out here, ladies and gentlemen. Anything else? Anything else that I haven't asked you? Defense counsel is going to have an opportunity to talk to you again also and go over some questions. Obviously, that's why you have these little clickers. Does anybody up here say, hey, look, moral reason or just a religious reason for some reason, and this is a question for everybody, feel that they cannot sit on a jury of this type of case? Anybody up here? And number, raising your hand, number 14, yes, sir? You work nights?
Yeah.
And so you feel that you won't be able to pay attention to everything? Okay, thank you, sir. Anybody over here? No one? Anybody over here? Any other concerns or anything else? Well, ladies and gentlemen, thank you very much. I'm going to take my leave at this point and turn it over to the court and defense counsel.
All right. Does anyone need a break before the defense begins? All right. So everyone, I'm going to give you a short break. I'm going to ask that you all be back by 4:05. Again, look to your left, look to your right. You're responsible for that person. So everyone needs to be lined up outside by 4:05. You seated? And ladies and gentlemen, there is another person who's come in. Usually students come in who may be in law school or who are in college and they want to watch jury trials. So they'll come in sometimes in different courts just so they can become familiar with the court process. So with that being said, I am going to turn it over to the defense. Defense, are you ready to proceed?
Sorry, Your Honor.
Are you ready to proceed?
Yes, Your Honor. Ready to
All right.
proceed.
You may proceed.
Thank you, Your Honor. Opposing counsel.
Good afternoon, ladies and gentlemen. My name is John Hunter. It's my pleasure to be representing Taymor McIntyre in this case. Just real quick, a slight change from what Mr. Garahan did for you, prosecutor. Each of you has a clicker that's been placed on your chair, and so to kind of speed things up and to try and get some answers that are going to be anonymous. So hopefully, get you all to be a little more open. We'd like you to use them. Several of the questions that I'll pose to you here, I'm going to put up on the screen on the PowerPoint, and then you'll have a choice, A, B, C, or D. Sometimes it's just A or B on those clickers. But before we get started, I'd just like everyone to look at your clicker again, because we've had a couple of times out of the courtroom. Make sure that the number on the back of your clicker is the same as the number of your jury card. Does anybody have the wrong number or the wrong clicker? Okay. All right. We're off to a good start then. Several things we need to talk about today, and because this is a capital murder case, there are a lot of intersecting points of law. There are a lot of complicated statutory structures that you all need to be at least aware of. I'm going to try not to be too much of a professor with you all today, but there's just a lot of content, so bear with me. But like we've talked about, this is supposed to be interactive. So if you have questions, there's some concern you have, I want to hear it. I want to have a conversation with you all. Even if you disagree with me, even if you really disagree with me, in fact, especially if you really disagree with me, I'd love to hear it. We want people to be open and honest with us, because that's the only way that the justice system works. You'll notice we stand up for you all when you come in the room. We'll be standing up for the 12 of you that are selected every time that you get up to go to the bathroom, every time the court's in recess. Why is that? Y'all are the most important people in the room, bar none. You are what we call the triers of fact, meaning that as this case goes forward, you all are the sole deciders, the sole arbiters of what's true, what's not true. You weigh all of the evidence, the testimony of the witnesses on the stand, the exhibits that are received, the documents, the videos, and you decide what to believe, what you think is just total bunk, what you think might be partially true. That's all your decision. The prosecutor can't make you see the evidence a certain way, and I can't make you see the evidence a certain way. And even Judge Boyd can't make you see the evidence a certain way, with a couple of exceptions that I'll explain in a moment. This is a capital murder case. Like every criminal case, it's governed by the highest standard of proof in the law, and not just in our law, but pretty much anywhere in the world. The American justice system, at least in theory, at least in name, prizes the idea that the standard of beyond a reasonable doubt is the way we protect the individual person from an oppressive government. That's part of what was behind the decision to break away from England, to end the monarchy, to set up this democratic republic. And it's critically important that we talk about it and that we make sure we don't water it down. So I want to talk to you all about burdens of proof generally. And because of the distances here, and gosh knows, my glasses, we're going to have some problems reading things. I'm just going to skip to the end where I sort of blew them up. And I've drawn you all this stair step to kind of think about different standards of proof and different kinds of evidence that we might see in courtrooms and in legal disputes of every kind. Okay. So Judge Boyd mentioned traffic tickets, and everybody seems to have had at least one unfortunate encounter with a uniformed officer of the law regarding a traffic violation. When you get pulled over for a traffic violation, it may be because the officer saw you explicitly violate a traffic code or a city ordinance or something like that. But officers can actually pull you over on the side of the road unless then being convinced that you committed some traffic violation. He can pull you over for what on the far left here in yellow is called reasonable suspicion, right? And that's just that the officer can point to some specific fact, some articulable fact that he believes would give a reasonable person the right to suspect that you've done something illegal. That could be a traffic violation, or it could be smuggling heroin, or it could be you have a dead body in the trunk. But it's some fact. That's more than a hunch. Can't be just a wild guess. It has to be something that he can verbalize and explain to other people. But that's all he needs to be able to pull you over and detain you and ask you some brief questions. If he were to see you walking down the street and he was able to point to something suspicious, like let's say you're walking past the front window of a jewelry store over and over and over again at periodic intervals for an hour, and he can point to that. I saw the guy pass the jewelry store window 12 times in 40 minutes. That's kind of weird. It's just not normally done. He can detain you on the street and he can pat you down. He can figure out, do you have a pistol on you? Are you going to hurt me? Is there some danger to me? Right? That's an intrusion on your sovereignty as an individual person. All the officer has to have for that, just something he can point to that would lead a reasonable person to suspect something's up. The next standard is probable cause. That's what they need to come into your house and search through your papers and effects, to look in your computer, to arrest you for a crime. And it's more than just suspecting that something is there. It's about reasonable belief. Are there enough facts to give a reasonable person the belief you've committed a crime? That's enough to search your home and invade your privacy in a significant way. It's also the first place we see that one of these standards can be applied in a court proceeding. Does anyone here serve on a grand jury? Nobody. Does anyone know what the grand jury process is about? Okay, well, we're here in a felony courtroom. This is a district court. To be charged with a felony in the United States Constitution says you have a right to have a grand jury consider whether or not there is probable cause to believe that you have committed a crime. Okay? They meet in secret. The defendant may not get an opportunity to speak in front of them, and if he is invited to do so or subpoenaed to do so, his lawyer can't be with him for that proceeding. And they hear evidence. They can't hear anything from the defense. All a one-sided affair with the prosecutor putting on their case, and they vote on whether there's probable cause to indict the person. You heard Judge Boyd talk about an indictment is not evidence in the case. The fact that someone's been indicted doesn't mean that they're guilty, and it can't be used as evidence to show that they're guilty. In other words, just because Mr. McIntyre has been indicted, and that's why he's here in front of you today, doesn't mean anything about the strength of this case, whether the prosecutor has a shred of evidence to support it. All it means is that some evidence was enough to give somebody the belief that maybe a crime has been committed. Okay? It's a very low burden. It's a very low threshold. The joke is that you can indict a ham sandwich. And that's oftentimes the case. The civil cases Judge Boyd talked to you about. If we were suing in a will contest about whether or not grandmother actually meant to change her will 3 days before she died. If we're going to sue somebody because they put up a fence on our property line, we prove that those wrongs have happened or that those circumstances are true by a preponderance of the evidence. That's just 51% or more. Okay? There's just a little bit more evidence on one person's side of the line than the other. That's all it takes to win in a civil case. Clear and convincing evidence is what they need to take your children away if you're a bad parent. We want to be absolutely certain. We want to be very, very, very convinced that it's in the child's best interest and that there's nothing else we could do before we're going to intervene and remove a child from their parents' household. I tell you about all of those other kinds of proof because if that's the kind of evidence that they marshal in a criminal case, the answer at the end of the day will be not guilty. None of that is enough evidence to find a person guilty of any crime in the United States. Okay? So if you're not sure if it could go either way, if it's a close call, if you think that maybe he's guilty, if you think he's probably guilty, if you think it's more likely than not that he's guilty, you're talking about these kinds of evidence standards and these types of proof that don't fly in a criminal courtroom. You have to have more, or else the answer is not guilty. It's only when proof beyond a reasonable doubt has been met, that a different verdict, a guilty verdict, can be returned. Now, Mr. Garahan talked to you a little bit about the idea of common sense. And I'm certainly not asking anyone to completely jettison their common sense. But one of the reasons why jury duty is such a pain is not just because you all have been taken away from your families and your work lives and all the responsibilities you have to do. Come and hear people like me talk all day. Part of the problem with it is that we are asking you to think about this in a way that is very different from the way that you conduct your ordinary lives and ordinary decisions. Because we're asking you to place this as a much more important priority in your life than it would otherwise be if you were watching this in the news, reading about it in the paper, talking about it with a friend. Okay? We are asking you to be testing the state's evidence against the presumption of innocence. Every person in the United States is presumed innocent. They can't be found otherwise unless the state proves every element of the offense that is charged beyond a reasonable doubt. Okay? And the state walked you through some of those elements that would be considered. The important point there is, as it was suggested, the date that the offense was committed on or about, at least that it happened before an indictment was returned, the county where the matter occurred, where the crime was said to have happened, the culpable mental state of the accused, what was going through their mind. Did they intend to do what they did? Did they know what they were doing? The act itself, in a murder case, the killing of another person. All those things have to be proven individually to you beyond a reasonable doubt. And as you're hearing the evidence and considering it, you have to be constantly cheering for and rooting for his acquittal as you hear it. Yes, I understand. I heard that. Ooh, that is bad. But I walked in here knowing that I start at he's not guilty. I walked in here starting with he's innocent. And I really have to make sure that the benefit of every doubt is applied for his benefit, not against him. That's a hard thing to do, especially in the course of a trial where you're going to hear some good things and you're going to hear a lot of bad things. You got to balance those things and test them. You constantly ask yourself that question. So this is a capital murder case, which means that it is a homicide case. I want to talk to you about the different grades of criminal homicide that we have, because there are a lot of interlocking and overlapping things about them that you all need to know going into this. Capital murder is the most serious kind of criminal homicide we have in the state of Texas. It's an intentional or knowing killing of another person in combination with some other aggravating factor, which takes most of the punishment line out of the equation. Statute authorizes death or life in prison. In this case, the death penalty is not being pursued, so there's only one possible punishment if Mr. McIntyre is found guilty, and that is life. The next kind of criminal homicide is murder, which just removes that aggravating element. It's a first-degree felony. It's an intentional or knowing killing of another person. But at the punishment phase of a murder trial, if you all hear evidence that the defendant acted in sudden passion, then you can lower it to a different level of culpability. And I'll explain sudden passion in a moment. Then there's manslaughter, which is reckless killing of another person. In other words, it wasn't your intention to kill someone, and you didn't do what you did knowing it would kill someone, but you were acting in a way that disregarded a substantial risk that human life would be taken. You were aware of that risk. Then there's criminally negligent homicide, which is that there was a substantial risk, but you were unaware of it, but you should have been. Before I talk to you about murder, murder is very simple. Intentional or knowing, causing the death of another person. So, in an intentional or knowing death of another person, we've decided in Texas that some killings don't merit the punishment that would otherwise be applied for a first-degree murder. And those are in situations where sudden passion is at play. The basic idea is that if you were acting under the immediate influence of sudden passion arising from adequate cause, then in punishment, even though you were found guilty of murder, the matter could be reconsidered as a second-degree felony and punished 2 to 20 years in penitentiary. The classic example of that would be that you walk into your home, you walk into your bedroom, and you find your wife in bed with another man, and you decide to kill the other man. That is the classic sudden passion example, right? Does everybody have a general sense of that? Does anybody have problems with the fact that we punish those potentially based on what you, the trier of fact, decide less harshly than we do other killings that are exactly the same, intentional or knowing killing? Okay. So let's get back to capital murder. The way that the prosecutor presented it to you, I don't think is entirely accurate. I want you to pay very careful attention to this because they have chosen to plead a case that has a higher burden because it has more elements than just simply an intentional or knowing killing. A capital murder is that the person commits the offense of murder, intentional or knowing killing of another, and that they intentionally commit the murder in the course of committing or attempting to commit robbery. So it is a specific intent crime. It is not enough that there was a robbery and that there is a murder. The two have to be committed in the course of each other and with the specific intent that the felony, in this case, a robbery, occurred. Okay, does that make sense? So a couple of examples. I decide that I want to go in and I want to get something at the 7-Eleven and I don't want to pay for it. And I have a gun and I'm going to rob the clerk and I kill the clerk while I'm robbing them. Capital murder all day long. Not hard to grasp, okay? But let's say I go into the convenience store. I don't have any intent on my mind to rob anything. I have money in my wallet. I'm ready to pay for my soda or whatever I'm purchasing. And I'm talking to the clerk and the clerk insults me. I lose my temper and I pull out my gun and I kill them. And they drop dead. And it's abundantly clear they're dead. There's no one else in the store. I put my gun back in my holster and I think, well, I've really done it this time. And I go over and I pick up the man's wallet and I take $100 out of his wallet and pocket it and walk out of the store. Is that a capital murder? No. Why?
Didn't have the intent to.
All right, so let me pause right there. Everyone, the court reporter cannot take down everything what everyone is saying when everybody's talking at the same time. So what needs to be done is if somebody wants to say something, you need to raise your card and then you will be called on. All right, thank you.
Juror number 20.
Person didn't go in there with the intent of committing a robbery
Right,
or motoring.
right. And didn't have the intent when they were pulling the trigger to rob either, right? Okay. So you see there that if the intent's formed after the fact, then it just can't be a capital murder, even though we have both of the same things. We have taking property of another without their consent, without lawful right to it, and we have a killing. Because those things don't line up in time, we don't have a capital murder. Is everybody okay with that? Does anybody feel like that's a technicality? I mean, if you kill people, that's bad enough. If you kill people and then you take their property, that should be capital murder, and you punish them just the same. Juror number 22. That's your belief?
Yes.
Okay. Does anybody agree with juror number 22? Number 7, number 48, 50, 45, 44, 17, 16, 6. Yes, sir, you have a question?
I think it's also subjective. I mean, in the course of the events that happen, it could be laid out very different. So if the person didn't have the intent, but they also carried a gun, we were open carry here as well. You understand the responsibilities of owning the gun. That is up to your discernment. You know, you already were given hopefully a training class too as well. So you have the responsibility as a gun owner. What to do with it?
Well, I mean, certainly, and we'll talk a little bit more about gun rights in a moment. I'll circle back to you on that. I'm sorry, who else that I didn't call your number when you held it up? Number 23? Okay. So when we talk about homicide cases at all, there are lots of different ways that those cases get filtered out. and lots of ways in which the evidence is presented to you all and we fight about it, right? Some murders may not be murder. Person may have killed themselves. They may have died of natural causes, but just under weird circumstances that make it look like they were murdered, right? Some murders are excusable. If somebody is insane and they're unable to appreciate the difference between right and wrong, and it's not a result of voluntary intoxication, they just they have a mental disease like schizophrenia, then that person might be not guilty of murder, not because they didn't kill them, but because it's excusable, okay? And then there are justifications. Somebody has taken the life of another person, but the law does not punish that as a murder, even though it is an intentional or knowing crime, because it was justified by certain circumstances that the law recognizes. And there are quite a few of them. Self-defense, defense of property, defense of the third person, necessity, which is kind of a weird one. The idea is that if the crime that you're committing is designed to punish a particular evil in society, but the reason you're doing it is to stop a greater evil, then it would be somehow justified. It's an unusual defense. Consent, certain types of violent acts are done by consent, but not homicides. Public authority, spies, soldiers, police, oftentimes have to, in the line of their duty, in the course of their work, kill people intentionally and knowingly, right? But they are doing so because they have the mandate of law to do that act. So I want to talk about self-defense. The burden of proof is never on the defendant. Mr. Garahan is absolutely correct about that. We have an obligation to produce some evidence to you that would raise the issue of self-defense. Some. It doesn't have to be a lot. It doesn't even have to be evidence that necessarily by itself you all would accept. But if the issue is raised by some evidence, a peppercorn of evidence, then the question of self-defense can be considered by you all, and the burden shifts to them to disprove self-defense. Does that make sense? Okay. The first question is, was non-deadly force justified in a killing, in a murder case? In other words, would you have been justified to punch the guy in the nose, or to shove him, or to throw something at him that's non-lethal? If you had that kind of a basic justification, then we can move on to the next question of whether lethal force was there. And the standard is when and to the degree the defendant reasonably believes that the deadly force is immediately necessary to protect him or someone else from another's use or attempted use of unlawful deadly force, or to prevent another's imminent commission of murder, sexual assault, aggravated robbery, or robbery. This is some examples of particular offenses you could use lethal force to prevent. It's presumed reasonable that your actions in using self-defense were necessary, immediately necessary, if the other person was unlawfully and with force trying to enter the actor or another person's occupied vehicle, habitation, place of business, trying to remove someone from their house, their car, or they were in the process of committing aggravated kidnapping, murder, sexual assault, sex assault, robbery. They didn't provoke the person against whom the force was used, and they weren't otherwise engaged in criminal activity. Okay. Let's talk about deadly force. Deadly force is force intended or known by the actor to cause, or in the manner of its use or intended use is capable of causing death, serious bodily injury, etc. I want to talk about this for a second. Deadly force. Sometimes deadly force could be with your hands, right? You could strangle somebody, you could stomp them with your foot, you could beat them to a bloody pulp, right? But in many instances, people use tools, weapons, to affect deadly force. So when we talk about deadly force, we oftentimes are hand in glove talking about deadly weapons. So what's an example of a deadly weapon? Someone raise their card so I can call it. Juror number 30. A knife, okay? Another example, number 7, a gun. Some other ones. Piece of pipe. Piece of pipe, number 17. Okay. Now, piece of pipe is an interesting one, right? Piece of pipe is not manufactured to kill people, right? Right, but in the manner of its use, it could become a deadly weapon. Correct. right? Could a car be a deadly weapon? What about the windshield of a car? Like you were breaking the windshield out of a car, or you were using a piece of glass and breaking over someone's head. Could that be a deadly weapon? Yeah. Now, Mr. Garrett talked to you about provoking the difficulty. All right. So the idea here is, as the prosecution pointed out, proportionality, but it's a little bit more nuanced than all of that. Okay. Like, if I told you, F you and F your mother, those are fighting words. Okay. But we know that just fighting words is not enough to justify you killing me because I said something really nasty about you and your mom. All right. But I was nevertheless provoking the difficulty. I started. I said nasty, mean things. But that wouldn't justify you going and getting a pistol and shooting me. So if that's what you decided to do in response to me using that bad language about your mother, I would still be entitled to use self-defense to kill you before you killed me. Does that make sense? The fact that I started it with words doesn't prevent me from being able to make the claim. And that can be applied up the ranks here. If I punch you in the nose, unprovoked, then I'm clearly provoking the difficulty, right? Punch you in the nose. But that's not lethal force, is it? So if your response to me punching you in the nose is you go out to your pickup truck and you pull out your 6 gun and you come back and you blow me away, the fact that I provoked the difficulty with non-lethal force doesn't inherently mean I just don't have a right to defend myself. Right? You've escalated the situation. You pulled a gun on me. Does that make sense? In cases of it provoking the difficulty, the fact that you legitimate, bona fide, provoke the difficulty with an excessive amount of force also doesn't mean automatically that you just don't get self-defense. Okay? If you provoke the difficulty, the use of force would not be justified unless you abandon the situation or communicate your intent to abandon the situation. And the other, nevertheless, continues or attempts to use unlawful force against you. So I pull a gun on you, and I yell some mean things, and I'm threatening, and it looks like I'm about to do it. And all of a sudden it clicks. Control your temper. This is a bad idea. I'm going to holster my gun. I'm out of here. And I walk out, and I'm going to my car, and I'm going, I shouldn't have done that. I lost my temper. I can't believe I was doing that. And the guy shoots me in the back of the head. Okay? Or he tries to shoot me in the back of the head, and I turn around and I blow him away. The fact that I originally provoked the difficulty doesn't mean that I'm automatically going to go down for murder if I survive this shootout. Because I tried to abandon the encounter. I tried to stop what I had done. And that kind of is a good rule, despite the fact it may not make sense at first, right? Because ultimately, what do we want the law to accomplish? We want to de-escalate conflicts. Just because I lost my temper, I drew a gun, doesn't mean I have to go through with it, because at the end of the day, I'll never be able to argue self-defense after this, right? That would be the result if we didn't have some way of sort of resetting the clock, starting over at square one. That's what the rest of provoking the difficulty is about. Yes, you shouldn't provoke the difficulty. And if you do it at your peril. You may not get self-defense. But if there are indications, and if there is evidence that you tried to dissipate the encounter or stop it, then the clock resets and we get to reassess self-defense all over again. We can forget about the past. We can focus on the moments that led to the death. Displaying a weapon is not always deadly force. Okay, in my example earlier, if I draw on somebody and I'm threatening, I'm going to kill you, we can probably say that that's deadly force. Okay, but for example, there was a case here in San Antonio about a year ago, maybe 2. There were neighbors and they were fighting about trash pickup day. And this lady was just not having it. And she hated that her neighbor was putting all of her bulky pickup trash right on the property line, right next to like where her lawn begins and her section of the sidewalk begins. And it just drove her crazy. And so she walked over and she picked up all the lady's bulky pickup stuff and she just started throwing it in the lady's driveway, blocking her cars and just causing a big scene. She was trespassing on her neighbor's property. And the neighbor came out and said, "Get off my property. Quit messing with my things. I wasn't trespassing on your property. My trash is where it's supposed to be. Leave me alone." This woman wouldn't hear it. She kept messing with the trash. She kept screaming at the lady. The lady finally reaches into her pickup truck and she produces her pistol. She said, "Get off my property." Right? That's not a display of deadly force. You have a right in Texas to produce a weapon as long as your purpose is limited to creating an apprehension that he will use deadly force if necessary. Okay? Think about this. You're an elderly man, you're in your 90s, you live alone, you don't get many visitors, someone knocks on your door at 3 o'clock in the morning. If you go answer the door, it might be prudent for you to have a pistol. Not just to shoot somebody if they're trying to break in, but to at least convey some ability to protect yourself, because you're otherwise not capable of physically doing it. We want people to be able to show the outside world, the potential dangers in the world, that you're capable of defending yourself. So we talk about reasonable belief, and you heard me object, because the prosecutor was explaining to you that the reasonable belief about whether it's eminently necessary to kill someone in self-defense, in part, hinges on whether or not it's objectively reasonable to believe that. And that's true, that's part of it. Is society willing to accept that that's an objectively reasonable cause to take another person's life? But it's not the only thing you have to look at. What you're doing is you have to put yourself in the shoes of the defendant. You have to ask themselves what they perceived, what they felt, what they thought. And you then need to ask whether or not, based on that understanding and that perception, it's objectively reasonable for us to accept that they believed it was eminently necessary to take another life. Okay? So, I mean, somebody's walking down the street on the 4th of July and they're throwing fireworks. Bang, big loud noises. Somebody shoots them. First guess is that probably is not objectively reasonable, right? Like, it's 4th of July, there are fireworks. What if you're a Vietnam veteran? What if you fought through the bloodiest part of that war, through some of the ugliest hellfires that they had, and you've had PTSD for 50 years? And that same scenario takes place, right? You have to take those kinds of factors into consideration. Along with that, we talked about how intoxication is not a defense, right? I get drunk and I do something stupid. The fact that I did something stupid the fact that I was drunk doesn't excuse me from what I did, right? But that doesn't mean you can't just completely ignore that person's mental state, where they were. You know, what if it's a 50 year ago war veteran who's been drinking to deal with their PTSD all that time, and it has affected their perception of reality? I think juror number 2, I think, Mark, that you do addiction counseling, right? Fair to say, drug addiction, alcohol addiction change like the way your brain works, and it takes a long time to get past that, right? Some people just don't get past that. Like, their brains just change because of abusing drugs or alcohol. So, I mean, in those circumstances, when you ask yourself subjectively, what did this person understand? What did they see? And you are going to be able to consider things like intoxication, things like drug addiction, along with that. As long as you look overarchingly at whether or not that perception, as this defendant understood it, is objectively acceptable and reasonable for society. Does that make sense? Is anybody not willing to do both the objective and the subjective work on that? You're just not going to be willing to ever consider the point of view of the defendant when you're deciding that question. Okay. Defense of property, real quick. In defense of property, you are also justified in using lethal force. You're justified in using lethal force to prevent theft in the nighttime. You're justified in using lethal force to prevent sexual assault, aggravated robbery, robbery, or the immediate flight therefrom. So people stealing your property, people breaking into your home to rape you, those kinds of things. You have to demonstrate that it couldn't otherwise be protected by non-lethal force, and that other attempts might expose you to a substantial risk. And we have defensive third person. If you're justified in using lethal force to protect yourself, you're justified in using lethal force to protect your property, you would also be justified if you have a reasonable belief that it's eminently necessary to do those things for another person. I can kill someone to save another person's life if I believe it's immediately necessary to do that. I'm sorry, sir, did you raise your hand? I talked about this a moment ago, but just to make it abundantly clear, for punishment, capital murder, there's only one option, and there won't be a punishment phase of the trial. It's life in prison. A regular murder conviction is 5 to 99 years in prison or life. And there would be a punishment phase of the trial for that. And in this case, the defendant is elected, if he is punished, to be punished by the jury and not the judge. If, as the punishment jury, you all decide that the crime was committed in sudden passion, then the punishment is now 2 to 20 years instead of 5 to 99 or life. Manslaughter also is 2 to 20. Negligent homicide is a state jail felony, 180 days to 2 years in jail. All right, now is the audience participation part of this show. The first thing I want to talk about is Mr. McIntyre. And I want to see if any of you all might be familiar with him. You've heard him by the name of Taymor McIntyre, that's his name. Mr. McIntyre is also an artist, a musician, and he goes by the nom de plume or the stage name of Tay K 47. And he has released a song called The Race, which is in the genre of rap. And I'm curious if anybody has heard that song, heard of Tay K 47, or heard of Taymor McIntyre for any reason. And what I ask you to do is just press your clicker with your answer. Two people have not responded, and one person. There we go. Everyone's responded. Great, thank you. Your Honor, may we approach?
Yes.
If you have heard of the case or Mr. McIntyre or the race, have you reached a conclusion about the guilt or innocence of Mr. McIntyre, as would influence you as a juror in finding a verdict in this case? In other words, I mean, because of these things, and because there's been some media attention about this case, we need to know whether you all have been exposed to that and whether that has informed your opinion about it in some way. So I need you all to let us know. Two more. Right, thank you all. Lastly, have you heard from any source about any of the lawyers or the judge in this case? Judge Stephanie Boyd, Jerry Goldstein, John Hunter, Thomas Lane, Jason Garahan, Megan Galloway. If you have heard about any of us, same question. Have you reached an opinion or a conclusion about the guilt or innocence of Mr. McIntyre, the defendant, because of what you've heard or what you've learned about the lawyers or the judge in this case? We got us a straggler. Remember, the answers to this are anonymous. It's not something we're going to, single you out and make you talk to everybody else here about. And we will know who refused to answer. Okay. This is just sort of an overarching philosophy question for you. I talked to you at the beginning about the presumption of innocence and reasonable doubt and how those things apply. This is a quote that's been attributed to a lot of people. I've heard it's attributed to Benjamin Franklin. But the idea that the way our justice system is set up, we are okay with the fact that it's possible 100 guilty people might go free as long as we are preventing one innocent person from going to prison. How do you all feel about that idea? I get that it's a tough one. That's a hard thing to consider. All right, circling back, we've talked a lot about guns, talked a lot about shooting guns. You're going to hear a lot more about that in this case. Obviously, part and parcel of self-defense laws, defensive property laws, they're tied up in the Second Amendment to the U.S. Constitution and what that document means. Okay? The Supreme Court of the United States has said repeatedly that the Second Amendment protects an individual person's right keep and bear arms to possess weapons, including handguns and long guns, for the purpose of self-defense. That's the core reason for the protection. That's what the Supreme Court says. It's obviously a very political issue, and I respect that. But that's the law. There are many people who believe that the idea of a well-regulated militia being necessary to the security of a free state is the actual purpose of the Second Amendment. It's about protecting the country. It's about being called up as a soldier or a militiaman. And it isn't about the right for some, 19-year-old dude to be walking around with an AK-47. So recognizing that a lot of people feel that way, that it isn't a personal right for self-defense. I need to know whether or not you all agree with what the Supreme Court says or not about that right. In other words, do you recognize that people have a personal right to keep and bear weapons for their own protection? Now, recognizing that question, I would like to know whether any of you, especially if you have opinions other than it's a personal right for self-defense. My beliefs about the Second Amendment prevent me from applying Texas's self-defense and/or defense of property laws. In other words, I can tell you all day long that the law in the United States, the law in Texas is that you have a right to keep guns for your protection. But even though you know that, you would be unable to follow the law in Texas about self-defense or defense of property if you were instructed on it. In other words, you could not find someone not guilty because of self-defense or defense of property because you believe that that's not a right that people have. They don't have the right to possess weapons. And while that question's being answered and being thought, I'd like to kind of get a sense about that. Is there someone who holds that position? We just shouldn't have
15 minutes.
Thank you, Chair. Number 33, were you raising your card? Oh, juror number 5. That's sort of how you feel about it? I'm so sorry, but the court reporter needs a yes or a no. So recognizing that's how you feel, do you have worry or concern that it might affect your ability to follow the law in this case? Okay, so if the judge told you that self-defense was an issue you must consider, the state has to disprove justified by self-defense beyond a reasonable doubt, you wouldn't be tempted to mess with the facts in your own mind or weigh things differently so that you would be able to avoid giving that person their individual right to protect themselves. Okay. Is anybody here who thinks that they would have that problem? They know that the law in Texas that you can use self-defense or you can even kill people to protect your property. But since you think that that's just totally wrong, or you think the Second Amendment doesn't mean that at all, you wouldn't be able to follow the law. Sort of similarly, but taking the Second Amendment out of it. Is there anybody here who, for just moral reasons, believes the taking of another person's life is always wrong? There are no circumstances that justify it, ever. And so even if you believe that the law of self-defense applied, even if the state failed to disprove it beyond a reasonable doubt, it is their burden, you would never let somebody be acquitted who took another human being's life. Does anybody here think that because Mr. McIntyre is here today, that he must be guilty of something? I talked to you about the grand jury process. Talked to you about probable cause to return an indictment. Talked about how the indictment's not evidence against him, despite the fact that we've told you that. Now we can tell you that till we're blue in the face. He's here Obviously, state of Texas thinks that he's done something wrong. That's why they're prosecuting him for it. You know, does someone feel like automatically that makes them think that he's probably guilty of something? It's okay to feel that way. I mean, we're talking about human nature, and I want you all to be candid with me about it. That's part of the reason why I'm asking you all to just answer this question on your clicker, so that you can just express how you really feel. I understand that that's how some people feel. Defendant who refuses to testify on his own behalf is probably guilty. Agree or disagree? Anybody here like bluegrass music? Juror number 12? Yeah. You like bluegrass music? You ever heard the song The Long Black Veil?
I haven't listened to it for a long time, but I probably.
There's a line in there when I think about the Fifth Amendment that I think is really good. We've talked about reasons people might not testify, and being nervous is often what people think about. The line is, 10 years ago on a cold, dark night, there was someone killed beneath the town hall light. There were few at the scene, but they all did agree that the man who fled looked a lot like me. The judge said, son, what is your alibi? If you were somewhere else, you won't have to die. I spoke not a word, though it meant my life. I was in the arms of my best friend's wife. And I've always thought that might be the best reason not to exercise the decision to testify. I want to talk about police for just a minute. The uniform carries a lot of respect, carries a lot of symbolism to it. And I think that sometimes that is something that impacts people. And so I want to know, is there someone here, when you're weighing the evidence in this case, who would be biased in favor of the testimony they hear from policemen? Solely because they are a policeman, solely because they have a badge, they've obviously been blessed by the state to do this very difficult work. That's of concern to me. I'd like to know about it. So if anybody here, has that opinion, I think it's understandable, but I'd like to know. Juror number 50. I'm sorry. Juror number 55. Right. So we see here that you might be in federal law enforcement.
Yeah.
What agents?
Department of Homeland Security.
Homeland Security. Okay. So I mean, that covers a lot of different things, from border protection issues to investigation of sex crimes online, to all kinds of things, right?
Yes, sir.
And so, being a peace officer yourself, I mean, would you be inclined or prone to give more weight to a brethren officer than you would?
Sir, yeah.
Okay. Do you think that would be something that you could ever put out of your head?
I'm definitely trying through this process, yes, sir.
Okay.
But I think being fair to the defendant, I probably have to admit probably more. Yes.
Okay. Any other members of law enforcement in our audience today and in our panel? Does anyone feel similarly to the way that Juror 55 feels? Showed your placard, so I really sense it. Just gauging based on your answer to the first one, Similarly to what I asked juror number 55, would you be able to put those opinions of police officers and your opinions about how believable they are aside as you judge this case? Would you be able to do it? And please be honest with yourself, right? If it's something that you think would significantly impact you, if you're going to take the word of a policeman versus the word of someone who is, a homeless person differently solely because of their outward appearance or that status, then we need to know about it. Yes, ma'am. Juror number 51.
I have a quick question. If you are an officer of the law, if you have been doing all of your training, you are trained to observe, correct? So I would take that trainable eye, that trainable observation, I would place a little bit more weight on that because they are trained to detect very different circumstances and lead through all the mucky muck. If that makes sense.
Okay.
So that's the reason why I'm saying that. Because that person has placed their entire life into that type of a training and belief for doing the right thing. Right?
Understood.
And having precision, basic, as precise as possible for recollection.
Now, you understand that, in order to have a presumption of innocence mean anything at all, your task is to, in this case, weigh the evidence of those policemen, right?
Right.
And that means being skeptical of what they say, asking like for proof, like not taking their word for it, right? So, I mean,
Look
recognizing.
at their training and you understand that they have gone through the rigors of training and they've had the experience.
So for you, that training and experience would be enough to dispel any other worries that you had about what they did. You defer to that training and experience generally over hearing what happened in their specific case or what decisions they made on the event. That wouldn't be what you do.
But I would look at their testimony and give the credence for their profession and for what they've been doing and listen to their testimony. Just as I would look at that homeless man and listen to his testimony.
Just off the bat, before they start, that's just how you're coming into it, is that they have this training and this experience and you're going to pay attention to that.
I'm definitely gonna probably focus my ears on more of what they say. And how they delineate what occurred.
Understood.
And I look at the homeless man as, you trust that homeless man to be his very best person and giving his testimony of what he saw or heard or observed.
That makes sense.
So I don't place more weight on the person, but on the training, I might say, you know what, he had a technical issue that he was able to pull out and bring some kind of light to, which brought up another whole different area for other, for you all to be doing your jobs and sort through.
Gotcha.
Whatever's going on here.
I'm going to move past that for a moment. This one's a very personal question, and I want you to know the answers are not going to be published. We're not going to be spreading this around. No one's going to be arrested for it. But I'd like to know if anybody here has had any experience personally with LSD, psilocybin, mescaline, DMT, psychedelic drugs. Similarly to my question about police officers. Yes, sir. Okay. Thank you so much. We'll just read. I'm sorry, what was your number?
35.
35. We'll just notate that. Appreciate it. No, I haven't. Similar to my question about police and how we have a tendency to perhaps give them more weight because of their training, because of their experience, because of what they do. I'd like to know how many people would just automatically discount what somebody says because they use drugs. mean, and there are obviously some considerations just off the bat, sort of like the same concept as a policeman, right? I mean, a drug user in America today probably acquired their drugs illegally without, physician consult. They're utilizing black markets. So they are engaging in behavior that is not above board and totally honest. And that is a concern or a consideration. But the question I'm asking is, would you, because of those sort of things inherent to being a drug user, an illegal drug user, would you just automatically write them off and not be willing to hear their testimony in the way?
So you have 20 seconds.
Okay. This one I think is the most important, and I'll have to leave you with this. I have a few other questions I'm not going to get to, but I'm going to give you this hypothetical. If the state proves murder to you beyond a reasonable doubt, but fails to prove the specific intent to rob, so they have not met all of the elements of capital murder, and for whatever reason, you are not given the choice to find him guilty of a lesser crime of murder. It's not one of the options on your verdict form. I need to know whether you all can follow the law and find him not guilty. So the way I phrase this is slightly different. A is absolutely not. I can't let a murderer go free. B, it would depend on how I feel about the defendant. C, yes, I could follow the law. I could find him not guilty, but I'd be really unhappy about it. And D is I can follow the law and acquit him, even though the state fails to prove capital murder, because I know he's guilty of murder. Like, even though I know he's guilty of murder. So you know that this man has committed a crime. He intentionally and knowingly, without justification, murdered someone. But the state got greedy for whatever reason and didn't give that option to you. They only said you can convict him of capital murder or acquittal. Law says you have to acquit if they haven't met all of their elements. And that's hard for people to do, right? He walks out of the courthouse. He's a free man. You can't follow that law. I need to know about it. When all 75 of you have responded, that will be my time. I want to thank you all for going down this trail with me. This really is the most important thing that we do as citizens. It is more important than voting. And I look forward to going on the journey with 12 of you throughout this trial. And we have, come on, last straggler. There we go, 75.
Yes.